Question is that the motion be agreed to. The Honourable David Parker.
Thank you, Mr Speaker. By my reckoning, there are 33 acts that are amended here, and I think you might have had poor advice from your ministry that there were 34, because there are only 33 parts to the bill. That's right. That's right. It might not be the most interesting piece of legislation, but I would have hoped that the minister would at least know the number of acts he was amending through this legislation. Mr. Speaker, this bill splits into 33 parts upon passage, because it amends each of those 33 acts, not 34. Mr. Speaker, well, the difference between 33 and 34 is probably a wee bit more important on this side of the House than it is on that. Mr. Speaker, Mr. Speaker, in terms of the amendments to the legislation that are recommended by the Select Committee, I endorse their caution in respect of some changes that were being made to these acts, particularly the Local Government Official Information Act and the Official Information and Meetings Act and the Official Information Act, both of which had amendments that went further than was probably appropriate for the Statutes Amendment Bill. As the Minister has correctly pointed out, the Statutes Amendment Bill is an omnibus bill. The reason that we don't generally have omnibus bills in this House is that they can traverse a wide area of information. Buried in the middle of them can be something significant. Submitters who might be interested in one piece of legislation won't, through the general notification that goes to members of the public from Parliament, be alert to the fact that there is a change in the law that could be significant to them, and therefore the public don't have the ability to raise the issue. The Fourth Estate don't get over the top of what might be a significant issue, and therefore this Parliament could, in a preemptory way, make an unwise change to legislation. For that reason, omnibus legislation is frowned upon, but there is one exception, and that is through the Statutes Amendment Bill, where Parliament agrees that there are technical amendments that are needed to lots of little pieces of legislation. It's generally in the nature of housekeeping. Sometimes it will be a drafting error. Other times there will be a non-controversial thing that has arisen just through changing circumstances over time, and all parties in the House are canvassed as to whether they think that the items are non-contentious. If any one party at any stage in the proceeding says, look, we've changed our mind, we think there is something controversial here, then the custom is that, and indeed it might be a standing orders requirement, I think, rather than a custom, that provision has to be taken out of the bill, so we truly are left with non-contentious matters. That's where we've got to here, and the reason that the provisions that are recommended for amendment by the Select Committee are coming out is for that reason. They do not think it's wise to introduce into the Local Government Official Informations and Meetings Act a definition of legal professional privilege. One of the reasons that they've come to that view is upon reflection, and I suspect they may have had a submission from someone to this effect at Select Committee. I wasn't sitting on it, but effectively the Select Committee is saying that the definition could be interpreted in a way that restricts legal professional privilege only to circumstances where court proceedings are in train or contemplated, which is but a subset of legal professional privilege that perhaps should apply more broadly to the Local Government Official Information and Meetings Act 1987. Therefore, the introduction of a narrower definition than the wider definition of legal professional privilege might have had the opposite intent to that which was intended. So by defining it more narrowly, they might have been overriding a wider legal professional privilege that already applied. So I can see the logic in that, and I think that that's wise to pull that out of the Act. Similarly, I think that the amendments that are made in respect of local government information meetings are appropriate. In respect of that issue, the committee said that the update to the legislation, which as the Minister said was recommended by the Law Commission, I think as a consequence of changing practices over time, uncontroversial, but the introduction of a discretion, if you like, for the local authorities to say in respect of an oral request for information that it should be particularised in writing was too general and could have been used by local government to obstruct people getting information in even the most mundane of cases. So if someone was coming in, they had an inquiry, the authorities said, oh look, no, we're not going to give that to you today, and the person then stood on their rights to get what was public information and said, I'm making a request under the Local Government and Official Information Act, someone who has been obstructive in the local government office could say, put that in writing, even though there's no need to put it in writing. And so the committee, as I understand it, has made some amendments to limit the discretion of the local authorities to always be able to say that routinely, and that seems pretty sensible as well. Sir, the other acts that are amended are listed in the Act. I don't propose to go through all 33 of them in detail, and Sir, that's with those comments, Sir, I record that the Labour Party is happy to support the second reading of the Statutes Amendment Bill number 4.